Trump's entire prosecutorial strategy just imploded in dramatic fashion. A federal judge branded his handpicked attorney a masquerading fraud, and 2 grand juries outright refused to indict his political opponents. This is not a minor procedural hiccup or small setback. This is a constitutional confrontation where the federal judiciary has drawn a firm line against the president attempting to weaponize the Justice Department. When Trump-appointed judges begin threatening disciplinary action against Trump's own lawyers, you know something seismic has fractured the administration's legal structure. Hit that subscribe button immediately because you won't want to miss any of the videos I release. So, what triggered this unprecedented collapse? Lindsay Halligan, the former beauty pageant contestant and insurance attorney Trump installed to prosecute his enemies, was recently forced out of her post as interim U.S. Attorney for the Eastern District of Virginia. This is not merely another political dispute or routine attorney changeover. This is the Justice Department's retaliatory prosecution engine grinding to a stop. And believe me, when federal judges start soliciting applications to replace your hand-picked prosecutor and threaten contempt proceedings, you know something massive has just detonated. Here's the complete picture of what has been unfolding. Tensions between the Trump administration and the federal judiciary have been simmering for months, fueled by aggressive attempts to prosecute Trump's political opponents without Senate-confirmed prosecutors. But everything escalated on January 20, 2026, when 2 separate federal judges issued devastating rulings within hours of each other. Chief Judge M. Hannah Lau, an Obama appointee, officially declared the U.S. Attorney position vacant and began soliciting applications for Halligan's replacement with a deadline of February 10. Meanwhile, Trump-appointed Judge David Novak issued a blistering order barring Halligan from even calling herself a U.S. attorney and threatening disciplinary proceedings if she continued the charade. The catalyst was unmistakable. Halligan's 120-day interim appointment had expired and she had been clinging to the position despite a November ruling that her appointment was unconstitutional. This was not about policy debates or standard administrative transitions. It was about a prosecutor acting without legal authority, signing indictments she lacked power to sign, and presenting cases to grand juries under false pretenses. Smash that like button if this is making sense so far. Here's where it gets truly serious. When Judge Novak reviewed Halligan's continued filings identifying herself as U.S. Attorney, he immediately recognized she had crossed a line that could not be ignored. And let's be honest for a moment. Judges threatening disciplinary action against prosecutors is extremely rare. It does not happen over routine disputes or technical disagreements. It occurs when a prosecutor has fundamentally violated the integrity of the legal process. Here's what multiple sources report happened next. On January 20th, the situation descended into full legal chaos. Judge Novak struck the words United States Attorney from the signature block of an active indictment in his court. He wrote that Halligan had no legal basis to claim she held the position in this court. He called her continued use of the title a charade, Ms. Halligan masquerading as the United States Attorney for this district in direct defiance of binding court orders. The judge specifically noted her lack of prosecutorial experience, which has long been the norm for U.S. attorneys, and said only that inexperience prevented him from immediately referring her for investigation. Meanwhile, Attorney General Pam Bondi issued a statement blaming Democratic senators, who weaponized the blue slip process, for making it impossible for Lindsay's term to continue. By evening, Halligan had formally vacated the position, leaving behind a trail of voided indictments and failed prosecutions. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. The real bombshell is not just Halligan's departure. It is what occurred before she left. Remember, Halligan was installed specifically to prosecute former FBI Director James Comey and New York Attorney General Leticia James. Trump had publicly demanded their prosecution, posting on Truth Social that we could not delay any longer and justice must be served now. Halligan delivered those indictments within weeks of her appointment. But in November, Judge Cameron McGowan Curry dismissed both cases entirely. She ruled that Halligan's appointment was unconstitutional from the start, meaning every action she took was legally void. The judge wrote that Halligan was a former White House aide with no prior prosecutorial experience exercising power she did not lawfully possess. The term unconstitutional sent shockwaves through legal circles. When a federal judge declares a prosecutor unconstitutionally appointed, it does not merely void one case, it voids everything. This move devastated Trump's entire revenge prosecution strategy. When your handpicked prosecutor is disqualified and her indictments tossed, it signals one thing. The evidence of improper appointment was so clear that even Trump-appointed judges could not ignore it. Claims of legitimate prosecution collapse when the prosecutor herself operates outside the law. This is not the first time a president's prosecutorial overreach has backfired. Recall Richard Nixon and the Saturday Night Massacre. Nixon tried to fire the special prosecutor investigating Watergate, cycling through Justice Department officials until he found someone willing to do it. The public backlash was so severe it accelerated his path to resignation. The pattern is clear. When presidents attempt to manipulate the Justice Department for personal vendettas, the system eventually pushes back. Then there were the Clinton-era independent counsel investigations. Ken Starr faced criticism for expanding his investigation far beyond its original scope, prompting reforms that limited future special prosecutors. The key difference: Clinton's prosecutors were at least legitimately appointed under existing law. Subscribe immediately if you haven't yet. This content does not exist anywhere else. And let's not forget the first Trump administration's attempts to investigate political opponents. Those efforts mostly stalled because career prosecutors refused to bring weak cases. Now, however, it is different. This time, Trump tried to replace the career prosecutors themselves. The pattern is clear. When an administration pushes too hard to prosecute political enemies, the guardrails eventually activate. So, what allegedly triggered this legal catastrophe? According to legal experts who have analyzed the appointment process, the Trump administration violated the Federal Vacancies Reform Act and possibly the Constitution's Appointments Clause. The statute allows the Attorney General to appoint an interim U.S. attorney for 120 days. After that, federal judges have the authority to name a replacement. Eric Sebert, Halligan's predecessor, had already been appointed under this provision. When Trump forced Sebert out for refusing to prosecute Comey and James, the administration tried to reset the clock by appointing Halligan. Multiple federal judges ruled this was illegal. Here's the kicker. The Justice Department tried twice to get new grand juries to reindict Leticia James after Halligan's cases were dismissed. Both grand juries refused. One in Norfolk on December 4, 2025, and another in Alexandria on December 11, 2025. Even after Trump publicly demanded prosecution, even after the full weight of the Justice Department pushed for indictments, ordinary citizens on those grand juries looked at the evidence and said, "No, don't go anywhere. The most explosive part is coming next." And here is what should alarm everyone. This is not just about one prosecutor or one failed prosecution. If a president can install loyalist attorneys outside the normal appointment process to target political enemies, prosecutorial independence becomes meaningless. Once that precedent is set, every future administration could weaponize the Justice Department without constitutional constraints. This puts the Trump administration in a nearly impossible position. On one side, they have publicly committed to prosecuting Comey, James, and others Trump has targeted. The base expects results. Walking back now would be seen as weakness or capitulation to the deep state. On the other side, every legal avenue they have tried has failed. Career prosecutors refused. Installed loyalists got disqualified. Grand juries declined to indict. They now have to explain why their entire prosecutorial strategy collapsed despite controlling the Justice Department. And here is the tricky part. There is no credible defense. Either the appointment rules were violated, in which case the prosecutions were illegal from the start, or the rules do not matter, which would require believing that presidents can staff prosecutors however they want, regardless of federal law. Legal and political analysts are calling this a constitutional crisis unfolding in slow motion. Harry Litman, former U.S. attorney and legal analyst, told reporters that the administration's approach represented a fundamental assault on prosecutorial independence, and that the court rulings vindicate the constitutional structure the founders designed. Emphasized that the separation of powers exists precisely to prevent this kind of politically motivated prosecution. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Ter. An old saying goes that a competent prosecutor could indict a ham sandwich. These panels hear only the prosecution's evidence with no defense attorney present to challenge it. The standard for indictment is merely probable cause, far lower than the beyond reasonable doubt standard for conviction. And yet, two separate grand juries composed of ordinary citizens from Virginia looked at the Justice Department's evidence against Leticia James and said, "No, not once, but twice in a single week." That's not a technicality. That's a wholesale rejection of the prosecution's case. Sources familiar with the grand jury proceedings told reporters that prosecutors struggled to present coherent evidence of criminal intent. The allegations against James involved minor discrepancies in a mortgage application from years ago, differences that could save her roughly $50 a month in interest. Grand jurors reportedly questioned whether this rose to the level of federal bank fraud worthy of prosecution. When even a prosecutor-friendly body won't indict, it exposes how weak the underlying case truly was. Meanwhile, Trump's core supporters are furious at the judges, including his own appointees who have blocked these prosecutions. Social media is flooded with accusations of judicial corruption and demands to remove judges who ruled against the administration. To the base, every loss is proof of a conspiracy against Trump rather than evidence that the legal strategy was fundamentally flawed. Things escalated further when Trump himself responded to Halligan's departure. He posted that she was a very talented lawyer who was forced out by weaponized Democrats. He claimed Comey and James got out on a technicality and insisted anybody that looks at it fairly would say, "Boy, are they guilty." He made no mention of the grand juries that refused to indict or the multiple judges who ruled the prosecutions were unconstitutional. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more extraordinary. The administration's response essentially confirms they have no legitimate legal path forward. Instead of addressing the constitutional concerns raised by multiple federal judges, the reaction was to blame Democrats and claim persecution. When your defense is attacking judges rather than disputing their legal reasoning, you've already lost the argument. Legal experts immediately flag the problem. Attacking the judiciary while simultaneously depending on it to reinstate your cases creates an impossible dynamic. Andrew Weissman, former FBI general counsel, noted that threatening judges while asking them to rule in your favor is not a winning legal strategy. This goes far beyond a single prosecution or a single prosecutor. It's about whether a president can use the Justice Department as a personal weapon without constitutional constraint. If there are no consequences for installing unconstitutional prosecutors to target political enemies, it signals that the rule of law applies only to those without presidential protection. It's not just about this administration. It's about whether the office of the presidency itself has meaningful limits on its law enforcement powers. If this blows your mind, hit that like button right now. Here's the situation. Multiple federal judges have now ruled that Trump's prosecutors were illegally appointed. 2 grand juries refused to indict Leticia James even after the full pressure campaign. James Comey's case was dismissed. Halligan is gone. The Justice Department's appeal is pending, but faces long odds given similar rulings in other circuits. This is no longer just partisan politics. It's about whether the constitutional structure designed by the founders still functions. When Trump-appointed judges start threatening Trump-appointed prosecutors with disciplinary action, we've entered genuinely unprecedented territory. If there are no consequences, it sets a dangerous precedent. Future presidents could staff the Justice Department entirely with loyalists willing to prosecute anyone the president dislikes. Keep a close eye on this story. The Fourth Circuit Court of Appeals will hear the Justice Department's appeal of Judge Curry's dismissal ruling. More prosecutors may be disqualified under similar legal reasoning. And federal judges across the country are watching to see whether the Justice Department respects their authority or continues to defy court orders. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Trump's entire prosecutorial strategy against his political enemies has collapsed under its own unconstitutional weight. His handpicked prosecutor has been forced out after judges called her appointment a charade. 2 grand juries refused to indict despite administration pressure. Career prosecutors resigned rather than bring politically motivated cases. And federal judges, including Trump's own appointees, have drawn a constitutional line that the administration repeatedly crossed. The numbers tell the story. 5 districts with disqualified prosecutors. 2 grand juries refusing to indict. 0 successful prosecutions of Trump's named political enemies. 100% failure rate on the revenge agenda. These aren't partisan talking points. These are the documented outcomes of the administration's attempt to weaponize federal prosecution. Legal observers are watching what happens next with the Fourth Circuit appeal. If the appeals court upholds Judge Curry's ruling, it could establish binding precedent that would prevent similar appointment maneuvers in the future. If the court somehow reverses, it would open the door to endless appointment gamesmanship that could allow any future administration to install prosecutors without Senate confirmation. This isn't just another news cycle that will fade away. This is a constitutional crisis unfolding in real time. What happens next could determine whether the Justice Department remains an independent law enforcement agency or becomes an extension of presidential will. The founders designed a system of checks and balances precisely to prevent this kind of executive overreach. We're watching that system being tested in ways it hasn't been since Watergate. The evidence is out there. The rulings have been issued. The grand juries have spoken. Now, we wait to see if the constitutional guardrails hold or whether this administration finds new ways to circumvent them. The stakes have never been higher. The legal losses have never been more comprehensive. And the constitutional crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.